Unit 8 Tenant Relations. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Explain the process of establishing a sound landlord-tenant relationship. Discuss methods of managing tenant relations. Identify methods for collecting rent on time. Discuss why and how to encourage lease renewals even when implementing rent increases. Summarize the methods by which a tenancy may be terminated and an alternative to litigation. Overview. The ultimate success of a property manager depends greatly on the ability to maintain good relations with tenants. Dissatisfied tenants do eventually vacate the property, and a high tenant turnover means greater expense for the owner in terms of advertising, redecorating, and uncollected rents. Effective property managers establish a good communication system with tenants and utilize intangible as well as tangible benefits to encourage tenant satisfaction by enforcing all lease terms and building rules and ensuring that maintenance and service requests are quickly dealt with. Careful record keeping will show whether rent is being remitted promptly and in the proper amount. Records of all lease renewal dates should be kept so that the manager can anticipate expiration and retain good tenants who otherwise might move when their leases expire. If a manager is ineffective for long, the owner's profits will disappear as tenants move out, expenses increase, and unpaid past due notices pile up. A good manager is tactful and decisive and will act to the benefit of both owner and occupants. Establishing a sound landlord-tenant relationship. Learning objective. Explain the process of establishing a sound landlord-tenant relationship. Landlords' and tenants' interests are not mutually exclusive, and the two do not need to be in constant conflict. The foundation for good landlord-tenant relations begins with a clear understanding of the rules and regulations and the move-in inspection. Effective servicing of the lease throughout the term of the lease further contributes to sound landlord-tenant relationships. Renewals are an important goal because they save the owner refurbishing costs, vacancy losses, leasing commissions, and renewed concessions. Tenants who are given diligent, fair, and equitable service will renew their leases for an additional term. These economic facts can be used to convince the owner that it is economically more advantageous to provide good service to tenants than to concentrate on short-term financial rewards. Key policy. Owners want a fair return on their investment in the property based on current market conditions. Tenants, on the other hand, want the best value for their rental dollar and all the services promised during lease negotiations. Though the manager's first responsibility is to the owner, the successful property manager will encourage both parties to work together because good tenants are an asset. Move-in inspections. The manager should inspect the premises with the tenant at the beginning of the tenancy to determine if promised repairs or alterations have been made or are in progress. At that time, the manager and tenant mutually agree to the condition of the premises and note any exceptions on the move and move out checklist. While having it all in writing is very helpful, so is a video or multiple pictures. Both the manager and tenant should sign this form and both should have copies. The same form can be used as a reference at the time the tenant leaves. Clear understanding of lease terms. At the outset of each tenancy, the manager should establish a basic understanding with the tenant on all matters relating to the lease terms. A tenant brochure that outlines all policies and procedures should be given to and reviewed with each new tenant. The tenant should also be told of the penalties for failure to comply with building regulations. An example of typical rules for residential property, the following topics should be addressed. Building rules and regulations. Handling maintenance requests. Procedures for paying the rent. Penalties for late payments or no payments. Terminating the tenancy. Security deposits. Resident regulations. General. The resident is responsible for the proper conduct of family members and guests and for seeing that they understand and observe all rules and regulations. While the buildings are well constructed, they are not 100% soundproof. Reasonable consideration of one's neighbors is therefore important. No resident shall play, or allow to be played, any TV, radio, hi-fi, organ, piano, or other musical instrument at a sound level that may annoy or disturb occupants of other units. Particular care must be exercised in this respect between the hours of 10 p.m. and 9 a.m. No resident shall make or permit any disturbing noises in the building or adjacent grounds by himself, his family, or visitors, nor permit anything by such persons that will interfere with the rights, comforts, or convenience of other residents. Hallways, laundry rooms, and storage areas are not play areas for children and should not be used as such. They should be used only for the purpose for which they were originally intended. The installation of aerials or antennas of any kind is not permitted outside of apartments or townhouses. Common areas of buildings such as stairs, stairwells, halls, lobbies are to be used only for the purpose intended. No articles belonging to owners should be kept in such areas. Boots and rubbers should not be left in corridors, nor should doormats be placed outside the front doors. To prevent water damage to their own or adjoining apartments, residents should close all windows tightly when leaving the apartment and building. When the resident is absent from the unit during the heating season, the thermostat shall be placed at a minimum 62-degree setting to avoid freezing pipes and resulting damage. Residents shall not store anything in their apartment or storage room that can create a fire hazard. Soliciting of any type will not be permitted in the buildings at any time, except by individual appointment with a resident. Patios and balconies. Mops, cloths, rugs, brooms, vacuum cleaner bags, etc. must not be dusted nor shaken from apartment windows, halls, or stairwells. Residents shall not sweep or throw or permit anyone to sweep or throw from apartments or balconies any dirt, dust, cigarettes, cigars, ashes, water, paper, or other material. Vehicles. No vehicle belonging to a resident or a member of the resident's family, guest, or employee shall be parked in such a manner as to impede passage in the street or to prevent ready access through the adjoining alley. Cars, trucks, and motorcycles are not to be driven on the lawns or in any area other than parking areas, streets, or driveways. Storage room. Each apartment has a numbered storage locker. If your storage locker has a lock on it or contents in it, call the office and the contents shall be removed. All contents must be placed inside the locker. Anything left outside the locker shall be removed. Flammable liquids or gas-powered engines and empty boxes are not allowed in the storage areas by fire code. It is recommended that all items be stored on wooden pallets or bricks in case of water leakage. Valuable items should not be kept in the storage locker. Lockers are in a low-traffic area of the building and hence are more easily accessible to burglars. Report any suspicious person around the area to the police. Laundry facilities. In consideration for other residents, common laundry facilities should be utilized only between the hours of 8 a.m. and 10 p.m. Equipment failure or malfunction should be reported to the number posted on the machine so that prompt repairs may be made. Windows. All windows should be draped with curtains or drapes. Blankets and sheets are not suitable unless converted to drapes or curtains, not simply tucked or hung over drapery rods. Fireplace. Please note that although the fireplaces in many of the apartments were once functioning, they are no longer usable. Fires are extreme hazards to all residents due to the dangers of smoke and carbon monoxide poisoning. For this reason, the fireplaces are decorative and non-functioning. Do not attempt to burn in them. The chimneys have been sealed to prevent heat loss and to help us reduce our heating costs. Manager's personal efforts. The prerequisite for a sound manager-tenant relationship is reciprocal communication. No matter the management specialty, the manager demonstrates goodwill and availability by communicating regularly with tenants by phone, email, or in person. A newly appointed manager must make a special effort to meet each tenant personally as soon as possible. Soliciting tenant input. On a regular basis, the manager should solicit tenants' comments on the amenities, services, maintenance, and general management of the building. Some managers do this very amicably by means of an annual or quarterly meeting or by a written questionnaire. Other managers have strong feelings against holding tenants' meetings, particularly in residential projects, preferring to maintain contact with tenants on an individual basis. One manager, on taking over a complaint-ridden complex, turned it around in a remarkably short time simply by appearing at the poolside every Saturday morning with donuts and coffee to solicit tenants' comments. Newsletters. Monthly newsletters or notices are an excellent way of educating occupants about current market conditions, improvements being made to the property, building activities, and other events, such as the appointment or promotion of management personnel. Newsletters can be printed or distributed via email. They can be simple or elaborate, but they should always be timely, accurate, and professional. Cultivating a sense of pride. The astute property manager, whether residential, industrial, or commercial, cultivates pride and a sense of community among the tenants. Living and conducting business in the building can be made as pleasant as possible by offering both tangible and intangible benefits. Amenities such as conference rooms, employee lunchrooms, child care facilities, game rooms, swimming pools, and tennis courts are useful in marketing the space and cultivating a stable tenancy. However, the manager's personal efforts can generate friendliness and loyalty among the tenant population even more than the amenities themselves. A little extra effort and creativity on the part of the manager can go a long way toward developing tenant pride and interest in the building. For example, the manager can publicize building activities that encourage tenant identification with the building as a whole. By remembering the importance of prestige and aura of desirability, the manager can easily enhance the image of the property with such thoughtful gestures as providing free coffee in the office cafeteria or seasonal decorating for the lobby every year. A satisfied, stable tenant population solidifies the earning capacity of the property and improves the stability of the income, thus fulfilling the manager's primary obligation to the owner. Handling maintenance requests. Key policy. Maintenance is the single most important factor over which the property manager has control. The manager must make certain that the tenant understands the building's maintenance procedures and the proper division of this responsibility between tenant and owner. The tenant should be told what areas are covered under the terms of the lease agreement and also how and to whom to make service requests. Requests in writing. The most important step is to insist that all maintenance requests must be submitted in writing, either by hard copy or email. Then, a system should be developed to quickly and effectively channel service requests to the appropriate parties. One way is to use carbonless paper forms of 3 different colors copies, each for the manager, the service person, and the tenant. Managers can scan the original into their software management programs in order to track maintenance requests and for billing. Using software management. Increasingly, managers are using software to scan and enter maintenance requests and to track progress and bill for such work. The work order command provides the manager with a way of entering and tracking maintenance requests from tenants and owners. The work order can be broken down between materials and labor and can even include comments from the worker. Additionally, any warranty may also be included in the software. Effective software can track work orders in progress in addition to work order history. Once the work order has been completed, it can be automatically transferred into the maintenance history file. Work orders can be edited at any time. Repairs can be performed in-house or by outside contractors and billed appropriately. If the manager wants to create a bill for payment to the vendor, the software will automatically carry forward the information to the report to be printed. Speedy response. The success of tenant relations also depends to a great extent on the speed of the landlord's response to the tenant's needs. Whenever a service request is made, the tenant should be told immediately when it will be taken care of. If the request is denied, the manager should be honest with the tenant and explain why. The best way to alienate tenants is to allow them to expect something and then to procrastinate and evade the issue if delivery becomes impossible. Excessive demands. Because the price of labor rises faster than that of any other commodity, service is becoming increasingly expensive. Hence, excessive service demands that call for additional personnel must ultimately result in disproportionately higher rents. The manager should listen courteously to requests and then explain to the tenant that providing extra services will necessitate a rent increase to cover the extra expenditures. Tenants who realize this are often more amenable to a compromise. Role of maintenance personnel. No matter how responsible management is to tenant demands, good relations with tenants can be destroyed if tenants are made to feel their requests are an annoyance. Maintenance personnel, the superintendent, and the staff of the management office should handle tenant requests in a pleasant manner. Likewise, service personnel should speak courteously, especially on the telephone, where they are judged only by their voices. On-site maintenance people should be neatly groomed. In fact, service uniforms are a good idea if economically feasible. The property manager must set a good example in this regard. Commercial and industrial variations. Although residential leases are generally uniform, commercial and industrial leases rarely have the same maintenance provisions. Therefore, a non-residential property manager usually must consult the lease to verify whether the requested action is the responsibility of the tenant or the owner. If the tenant is responsible, the tenant must be advised otherwise. The manager should promptly service the request. Managing tenant relations. Explaining the apartment leases. The basis of good tenant relations begins with selecting tenants who are able and willing to fulfill their obligations as stated in the lease agreement. By opening the lines of communication with tenants, the manager will build mutually satisfactory landlord-tenant relationships. Many managers recognize that some tenants do not take the time to read the lease carefully, so these managers take the extra time to highlight key clauses, such as when, where, and how rent is to be paid and the consequences for being late. They may emphasize other conditions such as parking arrangements, how long visitors can stay days, weeks, or months, the need to be respectful of other tenants' rights, noise and loud music, penalties for unauthorized pets, and so forth. The house rules should be presented to the prospect very early in the process, hopefully avoiding problems before they are even contemplated. Regular communication. One method of regularly communicating with residents is to publish a brief but informative monthly or semi-monthly newsletter. If major changes are being contemplated, such as extensive renovation, the manager may hold a meeting to explain when these events will occur. Tenant unions. As mentioned earlier, sometimes owners are intent on taking money from the property without providing necessary services. State legislatures have responded with landlord-tenant legislation in many states that allow tenants to form tenant unions. Conflicts can be avoided, however, by implementing a plan that brings management and residents together quickly in a controlled environment for the purpose of joint problem solving. A relatively easy strategy is to establish formal, regularly scheduled meetings with representatives of tenant groups. Once the tenants bring up a problem, they should be confident that management will be responsive, even if the answer is no. A manager should avoid a win-lose atmosphere with potentially destructive emotions so that decisions can be made in a business-like manner. Rent collection. Learning objective. Identify methods for collecting rent on time. From the outset, to best serve the interests of the owner, the manager should be clear as to when rent is due, where it is to be paid, and the penalties for being late or not making payment. The tenant should never be accommodated at the expense of the owner. Whether the leased space is an office, a store, a warehouse, or an apartment, it is standard practice for rentals to be paid in advance. When to pay. For convenience, accuracy, and speed in rent collection and record keeping, most monthly rentals are due and payable on the first of the month. The promptness with which tenants pay their rent is directly related to the efficiency of the manager's collection policy. Timely communication with tenants and tracking their payment progress is very important. Tenants will lose respect for a manager who is apathetic about rent collection. Encouraging prompt payments. The most basic way to encourage prompt payments is to establish a clear-cut policy for prompt payments and the provisions for default. At the time the tenant signs the lease, the manager should explain in a firm but friendly manner that after a specified time, the tenant will be treated as delinquent and that appropriate legal action will be taken if necessary. The manager must not bluff but should follow an established procedure that is rigidly adhered to without exception. The late fees. Two schools of thought exist concerning imposition of late charges on tenants who are delinquent in paying their rent. Some managers reject late charges, preferring instead to emphasize prompt payment and strict collection procedures. Others maintain that late charges are necessary to affirm rigid collection taking charge. Payment habits of tenants are a direct reflection of the manager's attention to and enforcement of firm collection policies. A manager taking over an existing complex must establish a consistent policy immediately upon arrival. An alternative to late fees is a discount for payment on or before the due date. Another variation is giving a cash payment for a certain number of on-time payments. Billing notices. Whether tenants receive a rent bill for each payment period is a matter of building policy. Itemized individual rent statements are a must for buildings whose tenants use variant services net lease. For example, an office building manager might need to issue separate bills reflecting each occupant's share of the operating expenses based on that tenant's utility consumption during the billing period. Commercial tenants may also be billed separately for electricity, light bulbs, special janitorial services, special carpentry or plumbing jobs, and late charges. Machine or computer-operated accounting systems can print rent bills and receipts simultaneously, but these expensive systems are normally restricted to larger properties and management firms. Residential tenants rarely receive monthly bills and notices. Using software management. First, the manager must enter basic data about the rental payments. Each property often has its own time frame for what it designates as late rent. The program can track payments including the bank account, deposit date, and deposit number for maximum detail. If the payment is not received on the due date, a late notice with appropriate late fee is generated. Eventually, if no payment is received, an eviction notice is generated and that process can begin. The lease renewals. Learning objective. Discuss why and how to encourage lease renewals even when implementing rent increases. Key policy. Unless the lease agreement includes an automatic renewal clause, it expires on the date specified in the contract. A tenant whose lease is expiring usually has no overwhelming need or desire to move to new quarters. Whether the tenant stays depends on the tenant-manager relationship and the terms of the new lease. The value of stable tenants. In a lease renewal situation, the manager must weigh one additional factor that was not present during the initial negotiations. A stable tenant with a history of timely rental payments is a proven quantity and an asset to the owner. Furthermore, the present tenant will probably make fewer demands for redecorating or other alterations than a new occupant would. Bargaining factors. Market conditions at the time of expiration will exert a strong influence over the concessions or terms granted under the new lease. In general, bargaining centers on the length of the new lease term, the extent of repairs, alterations, or redecorating to be done, and the amount of rent to be paid, concessions. The actual negotiation of lease renewals follows the same basic pattern as that used to obtain the initial rental agreement. If the general economic trend is inflationary, the manager should probably push for an increased rental rate and a short lease term or for an escalation clause. During a deflationary trend, the manager should favor a longer lease term to secure the current higher rental rate for as long as possible. The tenant usually will expect to receive other concessions in return for signing a longer lease at a fixed rent rate during a time of falling prices. Construction. The extent of repairs, alterations, or redecorating is influenced by market conditions, particularly by the competition in the market, and the manager must be current on concessions being offered by competitors. If an alteration desired by a tenant will become a permanent improvement to the property, the manager may be able to charge it to a previously allocated fund, which could allow some flexibility in the rental rate. Rental rate. One of the most important issues in lease renewals is the rental rate. Rent increases necessitated by rising operating costs are the most frequent cause for contract changes. With commercial property especially, the rent paid over the initial lease term may have included the cost of extensive preparation and tenant alterations. Because this work has been paid for by the time the lease is renewed, the rental rate may then revert back to the base rent, plus any increases deemed necessary by management. According to surveys made by BOMA and IRM, operating costs excluding taxes and insurance consume more than 43% of an office property's gross income and approximately 41% of an apartment building's income. Wages and taxes are currently increasing at a faster rate than rents in most areas. Rent increases. A 100% occupancy level may indicate that the rental schedule for the building is too low in comparison to the area market and that it is time for an increase. On the surface, both tenant and manager dislike rent increases. The former does not want to pay more, the latter fears a high vacancy rate will discredit him as a manager. On the other hand, wise tenants understand that economic realities probably dictate periodic increases. Managers may be more likely to support rent increases if their yearly bonus is tied into collected rent. In some cases, they will even recommend increases on available units and can help justify the increase if they were involved in the pricing decisions. Before deciding on any increase, the manager should survey the market to establish a market rent schedule for the property. Although it may be easier to communicate rent increases to tenants based on increased expenses, ultimately tenants generally tolerate the increase if pricing is competitive with the market. Cutting expenses by eliminating certain services or maintenance activities such as exterior upkeep is a self-defeating proposition. Tenants may not complain about these cuts as vociferously as they would about a leaking faucet that was not repaired, but a cutback in exterior maintenance expenditures will detract from the general appearance of the property. In these situations, over a period of time, lower quality occupants will replace the high-grade tenants, and the property will become even less desirable. The only effective method of strengthening a property's earning power is to raise rents while striving for better operating efficiency. Avoiding tenant protest. The threat of organized tenant protest against rent increases is overstated. Although the manager might receive an initial flurry of termination notices, the number of tenants who actually move after they have had a chance to shop the market will be considerably lower. Even if a few of the tenants do vacate, the higher rental schedule for the property will tend to absorb the brief vacancy loss until the units can be rented at the new rate. In fact, despite the loss of some tenants and a temporary increase in the vacancy rate, total income for the month immediately after the increase may sometimes exceed that for the previous month. Of course, this holds true only if the rent increase is justified in terms of the property and the area market. Increased services. When rents are increased, the manager should ensure that building maintenance and services either improve or remain at the same level. Often a simple cosmetic improvement will satisfy the tenants as to the owner's good intentions. Implementing a quickly completed improvement will help make a favorable impression on tenants at this critical time and allow the manager to postpone a more complicated project without losing tenant goodwill. Terminating the tenancy and alternatives to litigation. Learning objective. Summarize the methods by which a tenancy may be terminated and an alternative to litigation. Terminating the tenancy required notice. Notice of intent to vacate must be given within a certain period, which should be specified in the terms of most lease agreements. A letter from the manager outlining the procedures tenants should follow when terminating their tenancies can avoid many misunderstandings. Sometimes tenants are poorly informed as to the notice required and details they must follow when vacating their space. The letter should include a checklist for the tenant detailing the expected cleaning, post-occupancy inspections, return of security deposit. If a good tenant decides to move, the manager should contact the tenant immediately to find out whether the decision was prompted by any oversight on the part of management. If so, the manager should ascertain if the situation can be corrected, thereby retaining a valuable tenant. Even if the tenant's decision is irreversible, the manager should note the reasons behind it and file them for future reference. Exit interview. An exit interview between manager and tenant should be made in person, if possible, and should be a routine procedure. By analyzing the responses of all tenants who have moved recently, the manager can better understand the reasons behind the tenant turnover. Fair housing compliance. For many reasons, but none related to fair housing issues, the manager may refuse to renew a lease by giving the tenant appropriate notice of termination. This procedure can be used in lieu of the more expensive and time-consuming court eviction suit, provided the tenant's conduct is not too destructive and the remaining lease term is short. Key policy. To stay on firm legal footing, the manager who does not renew a lease should have proof of just cause for the refusal. Such termination may not be based on the tenant's race, color, religion, national origin, sex, familial status, or disability. Additionally, the manager is prohibited from serving notice in retaliation for the tenant's complaints to the authorities about building health and safety issues. Inspection of the premises. Whenever either party terminates a lease, the manager should inspect the space with the tenant after the tenant has removed all personal items. Whenever possible, the manager should use the same video, pictures, and form used for move-in, the one that was been signed by both the tenant and the manager, to determine if any damage has been done to the property and if the unit is being returned in reasonable condition. Any deductions to be made from the security or cleaning deposits can be calculated at this time. When the unit is empty, the manager will have to determine what repainting and refurbishing will be needed before the space can be rented again. To facilitate this procedure, the manager might carry a checklist similar to the move-in checklist to note the condition of each room or area, repairs needed, and when they can be scheduled. Similar forms should be used for commercial space. At least one state, California, requires that the residential property manager conduct a property inspection before the tenant vacates the property, if requested by the tenant. Return of the security deposit. Typically, state or local laws provide a detailed procedure for returning a security deposit. Generally, the landlord must account for how the security deposit is returned or retained within a certain period of time after the lease is terminated. Many states require that the reasons be documented in writing. A security deposit may usually be applied toward unpaid rent and damages or required repairs to the property. The landlord or manager must document in writing why any money is being retained. In some states, failure to do so will subject the landlord to legal penalties. State laws provide various ways to disperse unclaimed security deposits. Retention for damages. Acceptable grounds for retaining part or all of the security deposit typically include damages to the premises, unauthorized, non-standard, or irreversible decorating, excessive cleaning expenses, and unauthorized alterations. Charges made against the security deposit must be documented to establish the case against the tenant, and an inspection checklist is the best means of verification. Other documentation may include pictures of the damage or contractor's bills to clean or repair the premises. Last month's rent. In the past, residential tenants sometimes used security deposits as the last month's rent, but current legislation in some states forbids this practice. Even if it is not prohibited, leases should be written to prohibit it. One manager made the security deposit a different amount than the monthly rent tenants stopped thinking of it as rent. Security deposit legislation also covers the handling of security deposits when the ownership of dwelling units changes. Under the law, the person holding a security deposit must either return the deposit to the tenant or transfer it to the new owner while giving notice to the tenant. If a property manager is required by law to be licensed as a real estate broker, trust account laws and regulations governing brokers also apply to funds held by a property manager on behalf of tenants. Terminating the tenancy in court. Unfortunately, from time to time, tenants violate the building rules or do not pay their rents. Sometimes they are involved with criminal activities on the property. In these cases, the manager must take legal action on behalf of the owner. Allowing non-paying tenants or tenants involved in illegal activities to stay only prolongs the problem. Reasons for eviction. In addition to non-payment of rent, other permissible grounds for eviction of a tenant include breaches in the other terms of the lease agreement. If no written lease is in effect, grounds for eviction usually include non-compliance with building rules, misrepresentation or fraud, violation of the law, excessive occupants on the premises, excessive use of utilities, abuse of fixtures, illegal drug activity, unauthorized pets, and any miscellaneous activities that disrupt the other tenants. Notice before eviction suit. Generally, before legal action can be taken, the tenant should be given notice of the breach or improper conduct and an opportunity to rectify the situation. There may be some situations where this is not possible, such as assigning or subletting without consent, or if the breach violates the law, as in illegal drug usage. Then, if the tenant fails to make a good faith effort to correct the situation, the manager may initiate dispossess proceedings and obtain a judgment decree for damages. Note that many states have passed laws regarding the seizure and forfeiture of properties that are the sites of illegal drug activities, whether or not the owner knew of such activities. Special care should be taken when evicting tenants for illegal drug activities. It is always wise to consult an attorney. Eviction suit. The process of eviction and repossession of property, particularly if the tenant resists the landlord's action, is highly technical and requires the guidance of an experienced attorney. As a general overview, to bring an eviction suit, the manager must fill out an appropriate eviction form. In this case, one copy is served on the tenant, another is given to the manager's attorney to be filed in court at a later date, and the third is retained by the manager. Care must be taken when completing this form, as improperly drawn notices are frequently thrown out of court. An attorney familiar with local laws should draft this form. Precise eviction procedures are regulated by state statute. In some states, the manager must wait only 3 days after giving the eviction form to the tenant before allowing the attorney to file the notice in court in other states. This period may be as long as 10 days. Process. Notice of the filing of an eviction suit must be served on the tenant, and service must be made according to applicable state law. In some states, the defendant must be served in person. In others, service may be made on certain members of the family or other persons residing on the premises. In still others, posting a copy of the summons on the property is valid service on the defendant. Although some tenants will ignore an owner's notice to quit the property, it has been the experience of many property managers that after the service of summons into court, the delinquent tenant generally will leave voluntarily. If the tenant fails to appear at the court hearing, a default judgment is given to the landlord. If a tenant appears in order to contest the notice, a trial must be held to determine the matter. Actual eviction. Once the court gives a judgment returning possession to the landlord or the landlord is successful at a trial, the property manager must determine whether the tenant has physically left the premises. If the tenant has moved out and left nothing of value behind, the owner may take possession and re-rent the property. If, as sometimes happens, a tenant leaves personal property behind, the landlord must follow local statutes with regard to its disposition. If the tenant refuses to vacate the property even after the court rules for the landlord must secure a court order, and the sheriff or constable serving the court will physically remove the tenant from the property. Key point review. The effective property manager can establish personal but not unduly familiar relations with the tenant population, enforce all lease terms and building rules, and be able to handle residents who do not pay their rent on time. If a manager is ineffective, the net operating income from the property will decline. The manager is responsible for maintaining communication and mutual understanding between the landlord and tenant. The manager should discuss rent payment and collection policies and building regulations with all new tenants. Sound tenant relations are based on a good reputation for the management of the property. Tenants tend to renew their leases if they are getting the services and benefits they contracted for. Lease renewals eliminate the costs of high tenant turnover, and satisfied, long-term tenants take a personal interest in the upkeep of the property, thereby cutting the owner's maintenance costs. The manager should make certain that the tenant knows the correct procedure for making service requests and what services the tenant can reasonably expect. When service requests are made, the tenant should be told immediately either when the job will be done or why it cannot be completed. All maintenance and management office personnel should be pleasant and accommodating in their dealings with tenants. Case study: the tenant relations manager. Anna Chaplin manages a 75-unit apartment complex. One of her primary functions is to manage tenant relations. In 1 week, Chaplin had to deal with 3 unpleasant tenant situations. One tenant, Orloff, has been chronically late with his rent. For the last 3 months, Orloff has paid the rent only after receiving the landlord's official pay or quit the premises eviction notice. This month, Orloff is late again. A second tenant, Soto, has made repeated requests for various services and repairs, most of which have not been the landlord's responsibility. Soto just told Chaplin that he wants his apartment repainted. When Chaplin told him tactfully that the landlord was not obligated to repaint the apartment in the middle of his 1-year tenancy, he became very upset and threatened to start a tenant revolt. Snyder, who has been a model tenant for 5 years, recently informed Chaplin that she would not be renewing the lease when it expires in 2 months. When Chaplin asked her why not, she replied that she was uncomfortable with present management policies. What can Chaplin do to solve the rent delinquency problem with Orloff? What can Chaplin do to head off the threatened tenant revolt? How should Chaplin respond to Snyder's statement about present management policies?